20 years. And it was something the coalition had been saying needs to be added to the police association's contract, and it finally was this year. Okay, so the next thing it says officers will be banned from using offensive epithets, including mentals, which extends to when they're just talking to each other informally, and that's really important. We've seen this over the years where they degrade people by using a derogatory name which is an adjective as a noun, and it doesn't just occur with people with mental illness.
Okay, so that was the good news. Now we're going to talk about the places where the agreement doesn't go far enough, in our opinion.
Okay, so the city wasn't required to change the provisions of the collective bargaining agreement we just talked about that are prohibiting us from getting to the accountability that we want. And one of those provisions is a 48-hour rule. And the DOJ commented on the 48-hour rule in the letter of findings and said, I can't imagine that you would let a citizen wait 48 hours before they're investigated in a criminal matter. But when an officer is being asked whether they might have violated your policy, they have this, and this is the part of the contract that says, advance notice shall be given to the officer not less than 40 hours before the interview, if you can imagine that. And unfortunately, the agreement doesn't say anything about that. Oh yeah, Dr. Haynes tells us a great story that we love to hear. So when Kendrick James was killed in 2003, the officers involved went out to lunch or dinner, I don't know, they went out to a meal at Applebee's, and we don't know exactly what they talked about, but since they'd just been involved a few days earlier in shooting and killing an African-American woman who was unarmed, it probably came up. Given the 40 hours, even though now there's a directive that says they can't talk to each other after an incident like that, 40 hours is a long time to get your story straight that citizens don't have. Community members.
The new position of compliance officer or community liaison is created to oversee implementation of the agreement, but has no power before the federal court when recommending changes. So we have the new position, but the position doesn't have the power to recommend changes.
So if you look at the exact language here on the slide, basically it says that the court can decide how much weight to give the reports that the COCL writes up, and the court can, the parties, which doesn't include the COCL, the parties are the city, the DOJ, and this PPA, and the amicus party is the AMA coalition. Can give them to the judge, but the COCL can't necessarily directly address the judge.
There was much concern about the use of tasers, and while there are some new restrictions about taser use, we believe that the agreement retains and expands loopholes for what we think are excessive uses of the taser.
And again, you can see some of the language here in the agreement. It says, except in exigent circumstances, unless it presents a danger to the officer. They shouldn't use more than one. They use the term CW instead of taser, but they should use more than one taser at a time, unless lethal force will be permitted. So there are exceptions to the overuse of force. And keep notice, I guess we sort of skipped over him in the timeline. When he was killed in May of 2010, 3 officers tasered him at the same time. And I think everybody was hoping that would not happen again, but now there's an exception written into this. The agreement isn't really explicit about using the least force necessary, and we've had some discussions where the city attorney says that you can't really say that because you can't define the least force necessary, but I think there's something the community was hoping would be explicitly written in the agreement. And there are certain other, on the fact sheet you can see that there's not a matrix to say what the maximum force level is. So there used to be something called the continuum of force, where it basically said if a person is passively resisting, not violently resisting against an officer, there's only some certain things that you can do. You can show up for your presence. You can use verbal commands. But you couldn't go to the next step. But now that continuum is gone. So there's no guidance for the community, and there's no guidance for the officers exactly when you're exceeding the reasonable amount of force. And instead, it's based on a court case called Graham versus Connor, where it's the reasonable amount of force in the totality of the circumstances. And again, I know it's legalese to you, but that's how the city's going to be judging the use of force. Oh, and I shouldn't forget this part. It says that officers should display the ability to resolve confrontation without resorting to force over the course of their careers. So our concern is that this will be interpreted that if an officer, if a working officer uses force their first day out on the street, well, you know, maybe later on in their career, they'll get better. But if they use unreasonable force early on in their career, maybe they need to be let go. Yeah.
And I'm just going to pause for a moment. Just as on this, I'm speaking not as an AMA member, but as a minister of this church. We have been discussing the book by Michelle Alexander on Jim Crow, mass incarceration in the age of color blindness, and these are the sorts of things that we have to know about and address to actually change the current, very complex form of Jim Crow laws. So that's just me as a minister.